Welcome to Thought Leaders, featuring interviews with some of the best minds in the industry. Today's special guest is popular platform speaker and trial lawyer, Ilya Lirma. Hello everyone, I'm Steve Savant, syndicated financial economist and talk show host. In this segment, we're talking about why clients are successful in arbitration and litigation against their advisors, all from Ilya's best practices taken from her popular keynote addresses and seminars. And I have to say, I've noticed a trend, maybe I'm wrong here, but geriatric females in arbitration, crying with makeup running, you are going down. Am I missing? It seems that way to me.
Well, it probably does, but you have to remember that a lot of cases that get filed, first of all, get dismissed because there's not the evidence to support them. A lot of cases do settle, sometimes for nominal amounts, and the cases that actually get to trial and that make it to arbitration are the ones that have some significant merit, and they're usually being challenged pretty strongly and aggressively on the other side.
Ilya, I'm going to tell you something. There's nothing worse than a woman spurned, but if you don't make a call back, if she has a concern, if she has a question, and you're not calling back as an advisor, this is ranked #1 reason why we're going to arbitration. We didn't even call the client back to see if we could settle them down or figure out what was the problem. We felt, uh-oh, we're in trouble. Let's just ignore it. What is the value of ignoring it when we're heading for problems like this?
Well, to be candid, in any professional setting, the #1 complaint among patients of physicians, clients of attorneys, and obviously principals of producers, it is that communication. And if you're not making a concerted effort to return every single client phone call, you are setting yourself up for some real problems. Now, obviously, some of us have clients who are going to be a little bit more on the high maintenance end, and so maybe it's difficult to return every single one of their clients. But in my practice, it's always been that you return client phone calls within 48 hours. Everything else can wait. And if you don't get back to the client, you're going to have some significant problems. But I've been very fortunate because in the years that I've been doing this, I've not had one single complaint from a client that there was a lack of communication. And so again, that comes down to policies. And it comes down to whether or not that relationship that the client perceives. Again, the practitioner may have a very different view of what the relationship is. They look at it as professional, they look at it as transactional, it's a business relationship. But the person on the other side is looking at this as money, they're looking at this as trust, they're looking at this as family. And you have all kinds of emotional situations and contexts that are being played in to this relationship that the family has with you, and you're not honoring that. You know, you're not meeting your part in the relationship as far as they are concerned. You may have your own reasons for not returning the client phone call, but you're dishonoring the relationship. And that's when people start turning to attorneys. That's when they start coming to me and they say, you know, I've been calling my agent for the last 2 months and I'm not getting calls back. I have all these questions and it seems like every time I try to make a meeting, they're canceling or they have something else coming up. It's when the client is feeling dishonored by that relationship that you're gonna start having some problems.
Let me shift gears a little bit here. I am sitting, and this is one of my first non-binding arbitration things that I was involved in as a person witnessing. I went there to witness, and we had a contract, and the client thought that it said it was tax-free income. It turned out to be taxable ordinary income tax. Okay, so the complaint is, you told me it was tax-free. It turned out to be taxable. The agent said, you signed the document acknowledging it. The attorney in the non-binding just said, I'm going to read you a paragraph. He read the paragraph to the advisor and said, explain it to me. And he could not do it. And he says, if you can't explain it, how could she understand it? I don't care if she signed it or not. I want punitive damages. Your response?
Well, I honestly see it all the time, and that's the way it should be. Because if you've got contract terms, if you've got products that you're selling and you can't articulate how those are going to play in for your client or for the principal on the other side, and you can't explain how those things work, how is it that they're going to be able to make an informed decision? They're relying on you. You are the expert. You are the one who's been holding themselves out, and you can't give it in non-legalese. You can't give it in non-industry terms so that a person sitting across from you can understand. Absolutely, there should be liability in that context.
Even though the client signed the doc.
Again, that's one piece of evidence. The contract that the client signed is one piece of evidence, and they're going to be, a jury, an arbitrator is going to be very scrupulous in terms of applying some responsibility on the principal for having signed a document that says, taxable versus tax-free. But you have to remember that there's percentages very frequently in a lot of states. Here in Arizona, we have percentages applied to liability. Is it going to be 70% on the producer? Is it going to be 30% on the client? You're still liable for 70% of the damages experienced by that principal. And it's a result of your failure to be able to explain in reasonable and understandable, clear terms what it is this contract provides. And I've been in the context of examining insurance agents on the other side and asking them, well, you're saying this covers the client in a liability context. Tell me what liability means. And we went through 15 questions, and the producer on the other side could not give me a definition of liability without using the word liable in the definition itself. If you don't know what liability means, how are you explaining this to people you're selling the policies to?
I'm just thinking about our audience watching this right now going, how would I answer that? I think this is why we have shows like this. They're educational. They have an entertainment value, but they're educational. And we really want to clean up our act. We wanted to be good producers, very good fiduciaries for our clients. And maybe even using the word fiduciary could be wrong. I don't know. But listen, for more information on how to protect your practicing client arbitration and litigation like this we just spoke about, just click on the landing page address in the video description. We'll be right back with more from Elia Lim.
This is your website. Few people visit, and if it isn't attracting new visitors, it's not doing its job. Now you can drive more visitors to your website through dynamic content and email marketing with CreativeOne's Social Media Elite. Capture quality leads faster and easier. Engage your visitors with informative articles and videos to boost your online credibility. Plus, stay connected with existing clients and earn more referrals. All content is customized for you. It's time to introduce your website to the world. Call your CreativeOne sales team at 800-992-2642 or visit us online at CreativeOne.com.
In this segment, we're talking about how important it is to manage client relationships above everything else. All from Elia's best practices taken from her popular keynote addresses and seminars. Well, I have to say, I was remarking in between one of our sets that 72% of advisors are terminated by their female clients once dad died because there was no communication, there was no relationship management, and if things are going to go south in arbitration and trial, that could have been, a lot of it could have been circumvented if we would have kept the relationship online and the communication open. Now, I'm talking to a attorney, but also a woman, right? Relationships. We think, I'm telling you, as an advisor, many times we're so good about mathematics and how to build a retirement plan. And we have all the documents in the role. We understand beneficiaries and beta risk for my portfolio, but we don't understand keeping relationships with our client, male or female. And it's so important. And most of the time, by the time we get to arbitration, this is a relationship gone sour. Talk about why this is so important.
Well, the first part is to understand that there is a relationship, and we've talked about this in previous segments. There is a relationship, and you have to look at it not from your perspective. You have to look at it from the perspective of the person coming to you, the person sitting across the table, a little elderly couple, who wants to know what to do with their finances, or a young newlywed couple and what their future is going to look like. Why are they looking to you? I mean, to you, it's transactional. To you, it's business. You do this every day of the week. It's terms of art you use all the time, products you understand. And so when you discuss them, it's very casual. It's very nonchalant. You're used to money going up and money coming down. And your customers on the other side, they're not used to that. This is a first-time experience for them, for a lot of them. And so they're coming to you, and they do look to you. Again, money and these life events that surround the purchase of products, these are life events that are significant. They're emotional decisions. People are very afraid. They have old emotional attachments to money and what to do with it, and entrusting other people to manage it for them. And so they've made a very significant move. And you as a practitioner have to understand that it is more than transactional. Because, when you get in the context of litigation, you're dealing with an attorney, and an attorney wants to know what communications you've had for the last 20 years. A lot of that is because they're trying to figure out, they're hearing from their client, well, we had all kinds of conversations. We always talked. He knew about my kids, and I told him about when we bought the new house, and he knew we moved here. So to you as the lawyer is receiving a lot of relationship information, but then when you're making requests for discovery, none of that is being reciprocated. And so as a practitioner, I see the disparity. I see my clients who built a relationship and the producer who saw it as nothing more than business. And that's where the disconnect is. If you can close that gap and understand that your client has relationship values that they are imputing into the professional dealings that they're having with you, and understand that you have to nurture that. And that may be counterintuitive to gender. It may take a little bit of practice, but it's not a sophisticated aspect. You can understand that you want to comport yourself with integrity. You want to have good communication. All those things you might have in a personal relationship and friendship. You want to spend time nurturing those things. You want to do the same thing with your clients. You can't do it to the same degree, but you want to let them know that there's a personal aspect, not just because you want their business, but because you are willing to nurture that long-term relationship, and they're going to be with you in the long term. And they're going to understand if communication gaps fall through. They're going to start to become comfortable with where you are and where you take them.
Well, I'm thinking about sitting in my lobby of my doctor's office, and for years, my physician met him in the ER years ago, and all of a sudden, it's kind of like, well, I'm just one of the herd going through, very impersonable things of this nature, and then having a mistake on a pharmacy. It's something that could have been caught, and it wasn't caught because we didn't have our conversation. There was no bedside manner. There wasn't any of these things applied to our relationship. And I'm thinking about people going through, like you said, we're so used to dealing with so many clients, and hearing their personal and having relationships with them is pretty much last on our list, when it really should be first on our list. And this is kind of the weight of these relationships could insulate you from real problems in non-binding, binding arbitration, or even going to court.
Right, and you may recognize that that's just not part of your persona. It may not be an important part of your individual practice, but you may need to cultivate that position with someone who comes in as a junior associate and can have those conversations with your new clients. You have a front office person who may be more geared towards being the front line of defense for you. If you recognize that you're just not into client handholding right now, then that's going to be an important thing for you to recognize. But you can't just wash your hands of it and bury your head in the sand and think it's not going to affect you, because it is important. And the clients are going to certainly look to it. And they're going to be a lot more comfortable with somebody who is willing to sit down, hear their concerns, and they're going to be a lot less willing to go out and find an attorney like me who's going to pursue a claim against you.
Well, for more information on managing relationships in your practice for your team members and for your lawsuit referrals, just go to our landing page address on our video description. And for more information on all our shows, seminars, workshops, just follow us out on social media or visit us out on our website. I'm Steve Savant. We'll see you next time on Thought Leaders. And remember, keep thinking outside the box.